today's podcast, the biggest mistakes clients make at depositions is really critical. And I say that because there are two very important parts to any case that are perhaps the most important parts of any case. One is the plaintiff's deposition, and the second is cross-examination of the plaintiff at trial. And because so many cases do not go to trial, really the key is going to be how the plaintiff performs at deposition. And in my book, I have a chapter specifically about performance at depositions by clients and what works and what doesn't. Some of this podcast is in that chapter, but some of it is not. And it's important that every client really pay attention to the things in this podcast, because if the deposition goes well for the plaintiff, chances are that case is going to settle. And if it doesn't go well, most of the time the case may settle, but not for the amount of money or for whatever the plaintiff wanted before going to trial. The first mistake is not reviewing prior documents in the case that reflect the story the client has told. A lot of litigation boils down to how many times has this story been told in some form or another, and are the versions of the story consistent? One of the worst things a client can do is when being confronted with, let's say, the complaint that was filed in the case, filed in a federal court or a state court, and usually we do them by numbers. And the defense lawyer will take out that complaint, and the defense lawyer will say, okay, Mr. Plaintiff, let's take a look at number 17. In paragraph number 17, you allege that your supervisor told you she was not going to reasonably accommodate you anymore. Is that accurate? Well, if it's not accurate and you say, no, it's not accurate, that's death. How could it not be accurate? We've sent you the complaint for your approval prior to the thing being filed. So of course it's accurate. You had to have reviewed that document prior to the deposition. And this not just goes with for the complaint, it also goes for the client's interrogatory responses. It goes with respect to the EEOC filing. What we will typically do in our preparation with the client for this deposition is go through every one of those documents, and every lawyer should be doing that with his or her client. And if there's a problem with one of those documents, client has to say that at the preparation meeting. And that way this thing can be changed, and you can amend the complaint, you can amend your answer to interrogatories. But one of the absolute worst things a plaintiff can do is when being confronted with information that the client has already signed off on, is to now backtrack and say that didn't happen. Mistake number 2, lack of a fundamental understanding of the case theory. This may happen, and we do our best to object at deposition to any questions that have to do with the overall theory of the case. Because my position is the lawyer is the one who writes up the documents, the lawyer is the one who has the understanding of the theory, the lawyer is the one who's going to be fighting the summary judgment motion, the lawyer is the one who's going to be working on the jury instructions which reflect the law, and the person bringing the case doesn't really have to explain why under the law the person should win. That's really the lawyer's job. Depositions really should be limited in a perfect litigation world. Of course they're not, but we do our best to try to limit these deposition questions strictly to the facts of what happened. Now, having said that, the plaintiff, which is our client, generally has the responsibility to understand why he or she would win under the case. So, for example, if you have brought a retaliation case, you have to understand what that means. You have to understand that the defense lawyer will probably ask you questions about how you were treated before you filed your EEOC complaint. And if the answer at deposition is, oh, so-and-so treated me horribly from the start, you've undermined your case for retaliation. Now, of course, in our screenings, when we accept cases from potential clients, we go through all the elements. And then every client that signs up with us for litigation gets a copy of my book, Maximize Your Employment Lawsuit with My Top Secrets. And we expect that the clients will read the book, will understand what does retaliation mean, what does sexual harassment mean. Now, you'd be surprised at the pressure of depositions. You'd be surprised how quickly people forget details of various incidents that occur, particularly that are centers of litigation. It's just human nature that years go by, months go by, and that people just forget the blow-by-blow of what happened. Well, that's really critical because if your case is based on a certain set of facts which fit a theory of recovery, and you either don't understand that theory of recovery or you forget key facts of conversations, of incidents that occur, you, the plaintiff, have the burden of proof. So you absolutely have to understand what it is about which you are suing. And if you don't, and you walk into a deposition cold, you can really screw up your case. Number 3, taking out documents that you didn't previously provide your lawyer. I can't understand how some people do this. Prior to deposition, there is a phase of the case called discovery. There are interrogatory responses that you have to do, and at the same time, there are documents that you have to produce for your lawyer. Usually, they will involve email communications that you've had with your supervisor and management officials. The defense lawyer has the opportunity to obtain all of those prior to your deposition. I think I can probably count on one hand in my 22 years of litigation experience the numbers of times where a deposition was taken prior to the defense lawyer issuing discovery demands. So every single piece of paper, and I say this in my book in that chapter, that you go through your garage, every shoebox, everything that you have documents that are related to your case, the time to present those to your lawyer for discovery responses is way, way ahead of your deposition. So you absolutely cannot walk into a deposition room for the first time, get a question, pull out some new document that you've never shown your attorney before and you've never turned over. And people who do this can lead to really, really bad things from happening. Finally, for this segment of part 1 of the series here in depositions, number 4, thinking out loud. Thinking out loud, we do it all the time when we're in conversation with people. People ask us questions. When did such and such happen? And we don't know the answer off the top of our head. For example, when was it that I notice, sir, that you are wearing brand new cufflinks? When did you get those? Typical conversation piece at a party. And you may answer, oh, my cufflinks? Well, I'm thinking about this. I think my wife gave them to me. It must have been a year ago, Christmas. Maybe it was our anniversary. I think it was the time after I had gone to Las Vegas, and I had was at a conference, but I stopped off at some craps tables, and you see where this goes. You go on, and now you start volunteering information about being in Las Vegas at a craps table. Okay, interesting for a party, but let's say this was a divorce case, okay, and you got a question, when did you get those cufflinks? And you start going into a whole story here about how you were in Las Vegas and you were at a craps table, and what are you going to say next? And then there was some hooker that I met. And I mean, you see how this could absolutely destroy your claim there, and that any information that you volunteer could be used against you. You never want to think out loud at a deposition. You want to say something like, you get a when question. When did I get the cufflinks? December 26th, 2015. If you don't know right away, you say something like, let me think about that for a minute. And you think to yourself. You don't think out loud and volunteer more information for the defense lawyer. These are critical steps in securing an excellent performance at deposition, which will lead to good results in your case.